Assault. Contrary to popular belief, assault has nothing to do with slapping, striking, biting, kicking, scratching, or any other physical touching. The cause of action arises whenever a person is placed in a well-founded fear of imminent injury by the intentional threat or offer of another to cause him bodily injury by force. The cause of action arising from injury is called battery. If I phone you from Wisconsin while you are comfortably seated poolside at your cozy home in South Florida and say, I will now bash you in your nose, you have no cause of action because you have not been placed in well-founded fear of imminent injury. However, what I have done is called terroristic threats, and that does constitute a felony. I cannot hit you from Wisconsin if you are lounging by your pool in sunny Florida. If I walk up to you in a tavern and with a beer bottle clenched in my uplifted fist, shout in your face, I will now bash you in your nose, you have a cause of action for assault. If you have witnesses to testify on your behalf, you will probably win. The measure of damages can recover, the measure of damages you can recover, i.e., how much money the lawsuit may be worth, depends on the severity of the threats and the degree of fear the court believes it would cause a reasonable person in the same or similar circumstances, typically a jury decision. Elements to successfully plead a count for assault. One should assert each of the following. 1. An intentional threat or offer to cause bodily injury by force or force directed towards another regardless of whether any injury is caused. And 2. The threat was not lawful nor authorized by the plaintiff. And 3. Circumstances surrounding the threat created a well-founded, i.e. reasonable fear of imminent peril or bodily injury. 4. Defendant had apparent present ability to cause the threatened injury if not prevented. And 5, plaintiff suffered damages as a direct result. As you can see, my threatening you over the phone cannot give rise to this cause of action. However, if I threaten to club you on the nose with a beer bottle while you are standing face to face in a tavern or throw a beer bottle at you from across the bar, I have now committed a civil tort of assault, and all elements exist to support the cause of action. It is up to you, then, to allege all the facts necessary to state each element in your complaint, and if you omit any element or any element is not, in fact, present, I can move to dismiss for your failure to state a cause of action for which relief can be granted. However, when they move to dismiss, it's important for you to know that you can amend your pleading. You would do a motion to amend your pleading to make sure that you covered all the elements necessary, okay? Comments. Keep in mind that the cause of action arising not from violence itself, but from the defendant's threat or offer to do violence, and there must be actual fear, reasonable fear, fear of imminent, i.e. immediate bodily injury. A threat to do injury to property is not assault. Defense. Any communication or act done in pure self-defense is a defense. Thus, if you threaten me with a beer bottle and I wave an umbrella over my head shouting, "Do it, and I'll crush your head with this umbrella," you have no cause of action against me. Any communication or act done in defense of property is a defense. Thus, if you are in the act of stealing potatoes from my garden and I run toward you waving a shovel over my head shouting, "Get out of my garden or I'll pound you with this shovel," I have a defense to you, to your cause of action against me for assault. Spoken words alone do not constitute sufficient justification for assault. The old adage, "Sticks and stones may break my bones, but words will never hurt me," applies in cases where a threat of imminent bodily harm resulted from one person telling another person, "You are by far the ugliest mortal I have ever witnessed." To respond to such a statement with, "Hold still, you little varmint, while I pound your head in with this beer bottle," will subject you to civil liability for a tort of assault. Caveat. Threats to cause severe bodily injury may be justified only if made in response to a well-founded fear of imminent bodily injury to yourself. Threats to cause mortal injury by lethal force, however, are only justified in response to threats of lethal force or force capable of causing severe physical injury, i.e. threats that cause a well-founded fear of imminent death or severe physical injury. Whether the severity of the threat is sufficient to justify the responsive threat is typically a jury question. One cannot be excused from threatening to kill potato thieves. You can, however, chase them out of your garden with a shovel. If it is possible to withdraw from threatening situations, wisdom counsels you to do so, rather than actually cause physical harm to others for which you may become the unwilling defendant in a financially destructive, character assassinating lawsuit. Respond with force or threat of force only when absolutely necessary. Use of force or threat of force greater than what is privileged, even when acting in self-defense, may subject you to civil liability and possibly serve severe criminal charges. Now, I want to talk about this a little bit, because officers on the side of the road who are engaged in commerce that are charged with the duty of enforcing the IRC code, the revenue codes through the Department of Motor Vehicles, the driving codes and things of that nature, the motor vehicle codes. Okay, what they're actually doing when they say, if you don't give me a license, registration, proof of insurance on the side of the road, they're presuming and assuming that you're engaged in commerce, which would give them jurisdiction, all right? But you haven't colored them with authority yet, because you haven't given them the license, registration, proof of insurance proving that you would be engaged in commerce, all right? So, by a violation of their charter, because their police charter states very clearly that they have to be within the confines of the Constitution, you can invoke the Fourth Amendment. And the Fifth Amendment as well. I have the right to be secure in my papers, houses, persons, and effects. I have the right not to incriminate myself. And under the Sixth Amendment, absent of a warrant signed with an affidavit in support for my arrest, you have no cause of action or merit or warrant to even stop me in the first place, which is a violation of my unalienable rights to move from point A to point B, which constitutes an assault. And now you're threatening me while you're armed, which is aggravated assault, saying that if I don't give you these instruments, that I am subject to arrest and that you may arrest me. This is why they teach the police and police academy training about discretion. You have discretion. You don't have to necessarily enforce these things because they're not really law. You have discretion. And if you operate outside the bounds of your charter, and I can prove that pretty simply by submitting your charter, your corporate charter for the police department or the sheriff's department or the state patrol, into the court, showing that you are bound to obey the Constitution, and absent a true grand jury indictment, you had no warrant to stop me, you had no cause of action, you don't have a reasonable articulable suspicion that I'm engaged in commerce, and you don't have a reasonable articulable fact that I'm engaged in a crime, about to commit a crime, or have committed a crime. Chances are there's no APB out on the vehicle. That'll be simple enough to prove by simply getting a hold of dispatch and asking them what they were looking for at that particular time of the evening or day. Okay, so I'm just showing you how you can bring a cause of action against these guys. So it would go something like this. I, a man, have been caused harm by a man who at times, by a man named John Doe Smith, who at times acts as a police officer, okay? And the action is assault, or aggravated assault, because he did it with a weapon. He stopped me from going from point A to point B against my will, caused me to stop at a place that I didn't wish to be, that I didn't want to stay at, what constitutes a false arrest. He violated his charter in doing so. He cannot prove that I was engaged in commerce at the time that he engaged me, and because of that, I have been caused harm, damage, and loss. And that harm, damage, and loss needs to be remedied in the form of $5,000 a minute, okay? Pretty simple. You're just laying it all out there, right? Okay, so we went through the defense. We went through the caveat. Yep. Next is assumption of duty, okay? Assumption of duty. Most jurisdictions have reached the conclusion that an action taken for the benefit of another, whether for payment or reward, or even when gratuitously rendered, imposes an obligation on the person taking the action to do so with reasonable care. This is talking about bankers, okay? And this applies in a lot of situations, but I'm talking about when you give them the over-the-counter security, the promissory note, you have manifested a trust by giving them something of value, and they have given you nothing in return. They have not performed at this point, okay? And because of that, it manifests a trust. They have the assumption of a duty at this point, okay? And they are a fiduciary trustee, securities intermediary, hell-bent on negotiating that instrument to make sure that all parties are paid. They get a small fee for for the transaction that they do, and then they're supposed to zero out the account ledger, but they don't do that because they're lying, looting, pandering pieces of shit, hell-bent on destroying the American way of life, okay? Failure to exercise reasonable care gives rise to a cause of action for assumption of duty. In law school, they tell the story of a young man enjoying the sunshine on a beach crowded with many others when a cry for help is heard beyond the breakers. Dashing to the water's edge, he plunged into the surf ahead of the several other well-wishers who might otherwise have attempted to rescue. But, seeing our hero already ahead of them, a dozen strong swimmers wait anxiously in the surf, observing the rescuer's powerful swimming and praying for a soul in distress now only a few yards beyond his reach. At this point, however, the would-be rescuer sees the attempt may put him also at risk and turns back before the others in the surf can swim out to replace him. The drowning soul disappears beneath the waves, forever lost. Some might say the first fellow who started swimming to rescue has no duty and cannot be liable to the person drowning, since, after all, he was under no duty to begin with. The courts have held otherwise. One who undertakes to act for the benefit of another comes immediately under an obligation to do so with reasonable care. Had our swimmer not begun his rescue attempt, he would have no duty, and the family of the unfortunate drowned person would have no cause of action. As it turns out, however, his attempt dissuaded others from trying, others who might have succeeded. A duty was breached, and a cause of action arises accordingly. Now, I learned this when I was going to massage therapy school. We did a course on when coming up on crash scenes and stuff. If you start to administer care to somebody, the moment you start to administer care to somebody, you cannot stop. You have to keep going until your relief shows up. If you start and then you stop and they pass away, you could be held liable for it, okay? If they determine that, hey, if you would have just kept doing chest compressions and CPR, he would have lived. So if you start with one and you realize that his life is pleading away, and you see there's another one over there that you may be able to save, you can't leave the one you started with. You may be held liable, okay? Elements. It is important to note that the elements constrain this cause of action to certain facts, situations, so as not to create a chilling effect on those who might otherwise attempt to render it. 1. Defendant undertook gratuitously or for consideration to render services to another in circumstances a reasonable man would recognize as necessary for protection of the other's person or the other person's property. 2. Plaintiff suffered physical harm resulting from defendant's failure to exercise reasonable care to perform the services he undertook to perform. And 3. Defendant's failure to exercise reasonable care increased risk of plaintiff's harm. And 4. Plaintiff's harm resulted from reasonable and justifiable reliance on defendant's undertaking to render the services. The courts have clearly settled the issue. If you undertake to act for another's benefit in a manner reasonable persons would agree as necessary for the safety of the other person or his property, you have assumed a duty to do so with reasonable care and can be held liable for injury to that person resulting from your failure to act with reasonable care. Defense. Good Samaritan Act. Some jurisdictions have enacted statutory clarifications that limit the liability of persons who render assistance, medical or otherwise. In emergency situations, these statutes do not remove liability from those who act without reasonable care, but clarify the standard of care that must be observed. Be aware of these statutory clarifications in your jurisdiction and the case law that further refines those clarifications with regard to specific fact circumstances. Performance not begun. If the defendant has not actually undertaken to begin rendering services regardless of preparatory actions taken by him, the law will not hold him liable where the assumed duty has not begun. He is only liable to act with reasonable care after he assumes that duty by beginning. Battery. Battery, as a cause of action for the tort of battery arising when the plaintiff actually suffers harm or humiliation resulting from an intentional, uninvited, offensive touching. It isn't necessary that the touch cause physical injury. Herein, we are warned by the law. Some years ago, a carpet layer came to me complaining he'd been sued for battery as a result of merely touching one of his customers on the shoulder while telling her, "We don't have time to finish this job." You know, he had no intentions to cause physical harm. All he did was touch her with his outstretched index finger to punctuate what he was saying in response to her unreasonable demand that he use leftover remnants from the living room to carpet her hallway, a demand outside their written contract. She had raised her voice demandingly when he refused, and he punctuated his response by touching her with his finger. That was all the excuse she needed. The woman sued him for battery because he did intend to touch her, and part of his intent in touching her was to cause offense. Mild though it was, I was able to prevent her from obtaining a judgment. However, disruption to his business and the consequent emotional strain on his family resulted in great suffering, all because he touched someone with the tip of his index finger. That's battery. Moral of the story, we learn this shit in kindergarten. Keep your hands on your feet to your fucking self. It's not fucking hard. It's not rocket science. Don't touch people, all right? Elements. To successfully state a cause of action for battery, one must allege: 1. Plaintiff suffered a harmful or offensive contact caused by defendant. 2. Defendant intended to contact and the resulting harm of the offense or acted with reckless disregard for whether or not his acts would result in contact complained of and the harm or offense caused thereby. 3. Defendant acted unlawfully or without authority or consent. 4. Plaintiff suffered damages as a direct result of battery. The degree of force is immaterial, except that it may be considered by the court in determining the amount of money damages to be awarded to the plaintiff. It is not the degree of force or even the degree of hostile intent that gives rise to this cause of action. The cause of action arises where the touching is not authorized, okay? And remember, they keep saying lawful authority, not legal authority, lawful authority. They are two different things, okay? Comments. Negligently touching another does not give rise to cause of action for battery. However, if the person touched is unusually sensitive, the person negligently touching him may still be liable for damages resulting from negligence, but not from battery. Battery is an intentional tort, i.e., a cause of action that requires defendant intent as a necessary factual element that must be stated as part of the pleadings. Defense. Insanity. Since intent is a requisite element for a tort of battery, insanity, or in some cases extreme intoxication, may be a defense. The question is one of degree, i.e., whether the defendant possess the requisite mental capacity to intend his act. A merely intoxicated person may, in some cases, avoid liability for battery, yet remain liable for negligence if it is determined his intoxication was itself intentional. Self-defense. One is authorized to use reasonable force against another to protect oneself from physical harm. Thus, it is a defense to battery if one resisted physical force with physical force that was reasonable under the circumstances. Words alone. As explained under the heading for assault, spoken words alone do not constitute sufficient justification for battery. The adage, "Sticks and stones may break my bones, but words will never hurt me," implies in cases where the defendant causes the plaintiff bodily harm for saying, "You are by far the ugliest mortal I have ever witnessed." Words, no matter how demeaning or embarrassing, never constitute a defense to either assault or battery, i.e., to the threat of harmful touching or the touching itself. Hold your peace and avoid being sued. Caveat. As stated under the heading for assault, bodily injury may be justified only if in response to a well-founded fear of imminent bodily injury to yourself. Whether severity of a threat is sufficient to justify the response is typically a jury question. If it is possible to withdraw from threatening situation, wisdom wisdom counsels you to do so, rather than actually cause physical harm to others, for which you may become the unwilling defendant in a financially destructive character assassination lawsuit. Respond with force or threats of force only when absolutely necessary. Use of force or threat of force greater than what is privileged, even when acting in self-defense, may subject you to civil liability and possibly severe criminal charges. Sexual battery arises from any non-consensual sexual contact. Moreover, if Sue consents to sexual contact with Sam, and Sam knows Sue is ignorant of the fact that he carries a sexually transmitted disease, Sue has a cause of action against Sam for sexual battery, even though their contact was consensual. When we come back, we'll be talking about breach of contract. Again, this is a series of books we're ripping apart, created by a lawyer, and they're just little things I can add here and there to help you guys out. But it's important to understand these are very basic and foundational elements for you to bring forward your claim against agents and agency, a disgruntled neighbor that's trespassing and causing you harm, granting rise to a tort. It's important to understand the elements and what elements need to be in your pleadings in order to be successful in your suit, or if you have to defend yourself against a suit, to be able to identify all the elements that need to be in the pleadings, and if they're lacking or they're not there, then you can have cause for a dismissal for a claim being brought for which relief cannot be granted. The court doesn't have jurisdiction. We're lacking some elements here. So because of that, this court must dismiss. Anyway, when we come back, we'll be going through breach of contract. Again, I have a series of about 20 books. They're all 70 to 80 pages long, and they go into great detail of laying foundation down for you guys. And the reason I'm doing these videos is to help you guys out. Thanks for joining me, and thanks for all your support.